Hello students, I am Shanta Islam. In this lecture, we are talking about rule of law. The term rule of law is used as opposite to the concept of rule of man. What is means by rule of law? The primarily meaning of rule of law is that the ruler and the rule must be bound by the same law. No separate law or system can be provided for the ruler. In this lecture, I briefly discuss about history of rule of law, Professor Dicey and his theory of rule of law in true and modern sense, and provision for the ensuring of rule of law in Bangladesh Constitution. Now, as I have told you history of rule of law. The history of rule of law is that the history of emergence of political liberalism from the bondage of political despotism. The study of history of major legal system, for example USA, UK, France, etc., will necessarily reveal the idea that all of them had once experience of despotism, of better experience of despotism. All the despotic kings claim themselves to be representative of gods, and as representative of God, they claim themselves to be above the law, and under the cover of these designs, as did all the injustice and arbitrary actions over the subjects. But gradually protest against the despotism began to grow. In 13th century, Bracton says, the king himself ought to be subject to God and the law because law makes him king. This universal law was attributable to God. In the 17th century, Coke identified natural law with the common law of England, which he described as the perfection of reason. As a necessary outcome of arbitrary action by King John, there arose conflicting between the king and wealthy landlords or barons in arms. At the climax point of this conflict, they ultimately compelled the king to accept the terms embodied in Magna Carta. This Magna Carta was the first foundation of rule of law, because this Magna Carta was the document in the world history where for the first time we find a strong protest against arbitrary punishment. Whatsoever the doctrine of rule of law had now to reconcile with the other important doctrine of supremacy of the parliament. Either the law was supreme or the parliament was supreme. The outcome of the contention that the common law was the subject to such changes as the king in parliament must make from time to time. Henceforward, the law now recognized the supreme law was the common law or the statute law in whole of English law. However, this is a history of rule of law. Okay. Now we will discuss about Professor Dicey and his theory of rule of law. The general conception of rule of law or rule of law as a principle of constitutional government has become identified and crystallized with the Professor Dicey's uses of that phrase in his work, The Last of Work, the Constitutionalism, first published in 1885. Though the phrase has been in use since at last as early as the time of Aristotle in 4th century BC. Dicey has offered three basic features of rule of law. These are absence of arbitrary power, equality before law, and constitution is the result of the ordinary law of the land. Dicey's first principle is absence of arbitrary power. Rule of law means, in the first place, the absolute supremacy or predominance of regular law as opposite to the influence of arbitrary power, and excludes the existence of arbitrariness of prerogative or even of wide discretionary authority on the part of the government. A man may be punished for breach of a law, but he can be punished for nothing else. No man is punishable or can lawfully made to suffer in body or goods except for a distinct breach of law established in the ordinary courts for the land. In this sense, the rule of law contrasted with every system of government based on the existence by person in authority of wide, arbitrary or discretionary powers of the constraint. Equality before law. Dicey's second principle of the rule of law concerns equality. Every man, whatever be his rank or condition, is subject to the ordinary law of the realm and amenable to the jurisdiction of the ordinary jurisdiction. In this sense, rule of law convinced that no man is absolute law, that officials like provide citizens and under a duty to obey the same law, and there can be no special court or administrative tribunal for the state office. Though Dicey's theory has been criticized from different angles, the three important things, absence of arbitrary power, guarantee of citizens' rights, and the equality before law, over which he made emphasis, are universally recognized as the core of traditional theory of rule of law. However, these are the theory of rule of law. Now, I briefly discuss about rule of law in true and modern sense. The concept of rule of law may be used in two senses, narrower sense and wider sense. In narrower sense, it means that people will be abided by law and they will be governed by law only. On the other hand, in wider sense, it means that the government will be administered by law and under the authority of law only. Thus, what in essence means the rule of law is governed by law or not by man. But such a definition of rule of law still remains a traditional one as explained by Dicey. If rule of law means governed by law or according to law, then rule of law exists in every country, whether it is ruled by a king or a military director or a president. But no man with a minimum conscience will call this government as a rule of law. If we see the judgment of a case, then this matter will be clear. The judgment of Bhagavati in Bastan Singh versus State of Punjab in respect of rule of law is, law in the context of rule of law does not mean any law enacted by legislative authority, howsoever arbitrary or despotic it may be. Otherwise, even in dictatorship, it would be possible to say that there is rule of law, because every law made by the dictator, howsoever arbitrary and unreasonable, has to obey, and every action has to be taken conformity with such law. In such a case, too, even where the political setup is a dictatorial, it is law that governs the relationship between the man and state. But still it is not rule of law as understood in modern jurisprudence, because in jurisprudential terms the law itself in such a case of being an emanation of rule of law. Absolute will be of the dictator, and it is in effect and substance in the rule of man and not of law, which prevails in such a situation. What is necessarily element of rule of law is that the rule of law must not be arbitrary, satisfy the test of reason, and democratic form of policy seeks to ensure this element by making farmers of the rule of law accountable to the people. By the way, in the elements of the modern development in the matters human rights, the scope of rule of law has much widened. After the adoption of the Universal Declaration of Human Rights 1948, the International Bill of Human Rights 1976, and other international conventions on human rights, and also after the Congress of the International Commission of Jurists and some conference, the concept of rule of law has come to be identified with the concept of rule of man. A congress was held in New Delhi in 1959, where representatives of no fewer than 53 countries, judges, lawyers, and teachers of law. The Congress, though 4 committees, reported on the political safeguard required for the maintenance of the rule of law. Now, we will discuss a provision for the ensuring rule of law in Bangladesh Constitution. It has been placed in the preamble to the Constitution of Bangladesh that it shall be a fundamental aim of the state to realize, though the democratic process of a socialist society free from exploitation, a society in which the rule of law, fundamental human rights and freedom, equality and justice, political, economical and social will be secured for all citizens. In accordance with this place, the following positive provision for the rule of law has been incorporated in the Constitution. Number 1, Article 27 guarantees that all citizens are equal before the law and entitled to equal protection of law. Number 2, Article 31 guarantees that to enjoy protection of the law and to be treated in accordance with the law is the inalienable right of every citizen wherever he may be and of every person for the time being within Bangladesh, and in particular no action detrimental to the life, liberty, body, reputation or property of any person shall be determined except in accordance with the law. 18 fundamental rights have been guaranteed in the Constitution, and constitutional arrangement for their effective enforcement has been ensured in Article 44 and 102. Number 4, Article 7 and 26 impose limitation on the legislation that no law which is inconsistent with any provision of the Constitution can be passed. Number 5, in accordance with the Articles 7, 26 and 102 sub-article 2 of the Constitution, the Supreme Court exercised the power of judicial review, whereby it can examine the extent and legality of the actions of both the executive and legislative and can declare any of the actions void if they do anything beyond the constitutional limits. Number 6, right to be governed by a representative body answerable the people has been ensured under Article 7 sub-article 1, 11, 55, 56, 57 and 62 sub-article 2 of the Constitution. However, the above provisions are useful for the rule of law and to ensure the rule of law. See you for the next lecture. Thank you.